That's pretty stupid. I think that's really, really stupid for a county to hold a Christian Bible school class during the school day for 80 years and not realize that they were not allowed to teach only one religion. That just blows my mind. And then they take a young lady who's in her most impressionable years, and they put her in a closet to punish her for not participating in the Bible study in the public school. The Freedom from Religion Foundation has successfully sued the Mercer County Board of Education over a breach of the First Amendment freedom of religion. Very basically, the school hosts a public school Bible study class, and if you don't want to be a part of it, they really don't do anything to protect you or accommodate, a different classroom instruction. They literally put this young lady in a closet as like a what do we do with you while the rest of us are studying the Bible during public school education time. Now, this is the Christian Bible they're studying, and I thought we could go over some of the finer points of why they thought that this was an okay thing to do. So this is in Mercer County, West Virginia, I believe, and this has gone up to the 4th Circuit Court of Appeals. And the 4th Circuit Court of Appeals says this, and this is Diana Gribben Mott's circuit judge. For the better part of a century, Mercer County, West Virginia has offered weekly in-school Bible lessons to public elementary and middle school students through its Bible in the Schools program. Believing that the program violated the Establishment Clause, appellants Elizabeth Deal and her daughter Jessica filed this action against the Mercer County Board of Education, Mercer County Schools, Mercer County School Superintendent, and Memorial Primary School Principal. The district court dismissed their complaint, reasoning that the appellants lacked standing to sue and that their claims were not ripe. They now appeal. For the reasons below, we reverse and remand for further proceedings consistent with this opinion. That means that the lower court will have to hear the case again, this time deciding things in a way that's consistent with the instruction of the appeals court. So sometimes an appeals court simply overrides a decision and said, no, here's the new ruling. Other times it says, no, we think you not only made the wrong decision, but we want to make sure that you understand that you have to make the right decision, and here's why. So we're going to make you do it. We're going to make you write it in your own words. It's kind of like the teacher giving you a red-lined essay and saying, okay, well, here's the bad parts of your essay, now go rewrite it. So it's not necessarily a punishment for the judge. It's supposed to be instructive, but you can bet the lower court judge is not happy about having to rewrite their opinion. The following facts are taken from appellant's amended complaint, which we must accept as true for the purpose of this appeal. The Bible in the Schools, or BITS program, is a Bible instruction course that has been taught in Mercer County schools for 80 years. The program offers 30 minutes of weekly Bible instruction for elementary school students and 45 minutes for middle school students as part of the regular school day. Participation is ostensibly voluntary, since parents must return a permission slip to allow their children to attend. But in practice, nearly all students participate. Since 1986, the county itself has administered the BITS program and designed its curriculum for use by specially employed BITS teachers. The curriculum includes lessons covering Moses, the crucifixion, the Ten Commandments. Notwithstanding the county's administrative role, the program is privately funded by the Bluefield Bible Study Fund, a 501c3 organization. That's really weird to me, because it sounds like one religion was pushed. I didn't hear anything about them telling stories from the Quran or the Torah, or anything from Buddhism, or anything as an alternative to religion, as in what happens if you don't believe in a god or whatever. It sounds to me like they were teaching one religion for 80 years above all the other religions. So With that in mind now, I'm going to continue, and let's see what some of their excuses were. Appellants Elizabeth Deal and her daughter, Jessica, live in Mercer County. When Jessica entered 1st grade at Memorial Primary School, her mother received a permission slip to allow Jessica to participate in bits. Deal, who identifies as agnostic, sought to teach her daughter about multiple religions and to allow Jessica to make her own religious choices. This is the way I would want to do it. I would be happy to allow my children to choose, and I would support their choice, even if they chose something I didn't believe in. I've spent enough time traveling, and I've known enough people in this world that there is no one religion that makes people evil or great. It is really the individual person who decides how good or bad they want to be, and the rest are personal choices. I personally find the Hindu religion to be very beautiful. It's not something I believe in, but why would I wouldn't want to discriminate against them. I wouldn't want to say that the Christian religion is better than Hindus. I don't understand why there's this, we must prevail even through illegal means kind of thing from certain people. I'm not saying everyone in a religion does this, but some people, some bad apples spoil the bunch. And I'm just always wondering why someone tries so hard to get their religion pushed above everyone else's, when to me those sorts of beliefs were always very personal. What I believe about what happens when I die or where I come from, I don't see how I could tell another person that they have to believe the same thing. That seems extraordinarily arrogant to me. Because Deal believed that the school's weekly Bible lessons were incompatible with these goals, she withheld her permission. When the Bible program began later that year, a school official separated Jessica from her classmates and placed her in a coat room area, like literally the closet, in the back of the classroom during the Bible class. After Deal protested to the principal, school officials relocated Jessica, usually to another classroom, the library, or a computer lab. The county never offered any alternative instruction to Jessica during the BITS program. Jessica alleges that she faced harassment from other students because she did not participate in BITS. For example, one student told Jessica that she and her mother were going to hell. Their experiences left appellants feeling marginalized and excluded in the community, ultimately prompting Deal to enroll Jessica in a neighboring school district for the 4th grade, where she has remained since. And I don't know which school district, but if I recall one of the articles, it was actually in Pennsylvania. She had to go to a different state because the propaganda from this program had created such a backlash against her. Deal alleges that the Bible program and the treatment Jessica received were a major reason for her removal. Shortly after relocating Jessica, appellants filed this action alleging that the program violates the Establishment Clause of the First Amendment, and they sought injunctive relief and nominal damages. Nominal damages would be like the minimum damages they need to cover their costs. The county moved to dismiss for lack of standing and failure to state a claim. During the briefing period, the county notified the district court that the Board of Education had suspended the Bible program for at least a year to review the program's curriculum. Counsel for the county later suggested at oral argument before the district court that the suspended version of the program would not return. But news reports, which Mercer County itself submitted, quoted Superintendent Akers as saying that the county was fighting to retain the program. After oral argument and supplemental briefing, the district court granted the county's motion to dismiss, reasoning that appellants lacked standing to sue and that, as a result of the program's suspension, their case was no longer ripe. This appeal followed. The county maintains that because Jessica no longer attends a Mercer County school and has not vowed to return, appellants lack standing to seek injunctive relief. Unlike questions of mootness and ripeness, the standing inquiry asks whether a plaintiff had the requisite stake in the outcome of a case at the outset of the litigation. When standing is challenged at the pleading stage, we accept as true all material allegations of the complaint and construe the complaint in favor of the complaining party. We review a district court's lack of dismissal of standing de novo, which means brand new from the beginning. To satisfy the irreducible constitutional minimum of standing, a plaintiff must have suffered an injury in fact that is fairly traceable to the challenged conduct of the defendant that is likely to be redressed by a favorable judicial decision. We usually call this injury, cause, and remedy, or injury, cause, and damages. And there's obviously more to those words than just those three, but there's a little obtuse in the legal language, because appellants' asserted injuries are clearly traceable to bits. Only the first and third elements of standing, injury in fact, and redressability are at issue here. The county first contends that appellants have not adequately pled an injury in fact. To establish an injury in fact, appellants must show that they suffered an invasion of a legally protected interest that is concrete and particularized and actual or imminent, not conjectural or hypothetical. By the way, those are the legal standards that you will need to know on your bar exam, so you might want to hear that again. The injury part of standing requires suffering an invasion of a legally protected interest that is concrete and particularized and actual or imminent, not conjectural or hypothetical. The concept of injury for standing purposes is particularly elusive in Establishment Clause cases. As in Establishment Clause, the prohibition on the federal and state governments from establishing a religion, a state-sponsored religion. This is so because Establishment Clause injuries are often spiritual and value-laden, rather than tangible and economic. As such, an Establishment Clause injury may be shown in various ways, but no matter how rare or unique the injury, a plaintiff still must carry the burden of demonstrating each element of standing. Appellants allege 3 separate injuries, 1 already sustained and 2 ongoing. First, they assert that while Jessica attended school in Mercer County, they suffered direct, unwelcome contact with the BITS program. See the previous case, finding an injury based on unwelcome direct contact with a religious display that appeared to be endorsed by the state. Second, they allege that they continue to avoid the BITS program by sending Jessica to a neighboring school district, expending their own resources to do so. And that's saying that there's a case called Valley Forge, establishing that standing exists where impressionable school children are subjected to unwelcome religious exercises or are forced to assume special burdens to avoid them. Finally, appellants assert that they suffer from ongoing feelings of marginalization and exclusion. The county concedes, as it must, that each of these allegations state cognizable injuries. But, notwithstanding the ongoing nature of 2 of appellants' asserted injuries, the county argues that these harms are not sufficiently imminent to permit a court to grant injunctive relief. This framing of the issue fundamentally misapprehends appellants' claims. Appellants seek relief not just for past injuries or from some sort of speculative future injury which would implicate the imminence requirement. Rather, appellants also claim to suffer from ongoing actual injuries, near daily avoidance of contact with an alleged state-sponsored religious exercise, and enduring feelings of marginalization and exclusion resulting therefrom. Moreover, to the extent that the county asks us to import the imminence requirement into cases involving ongoing injuries, its argument makes little sense. The Supreme Court has always described and treated the 2 concepts, actual ongoing injury versus imminent injury, as disjunctive or 2 separate things. Our own application of these principles illustrates the point. In the case Kenny v. Wilson, for instance, we considered a vagueness challenge to 2 South Carolina statutes assertedly used to curtail the First Amendment rights of public school students. We recognize that in such a case, plaintiff can satisfy the injury in fact requirement for prospective relief by either demonstrating a sufficiently imminent injury in fact or by demonstrating an ongoing injury caused by the chilling effect of self-censorship. Noting that plaintiff may seek prospective relief against ongoing or imminent First Amendment violations. Unlike injuries that occurred in the past and may no longer be imminent, ongoing injuries are, by definition, actual injuries for purposes of Article 3 standing. The county further contends, and the district court held, that since Jessica no longer attends a Mercer County school, appellants also lack standing because an injunction would not meaningfully redress their injuries. To satisfy the redressability element of standing, a plaintiff must show that it is likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. The burden imposed by this requirement is not onerous. Plaintiffs need not show that a favorable decision will relieve their every injury. Rather, plaintiffs need only show that they personally would benefit in a tangible way from the court's intervention. In fact, an injunction here would redress both of the ongoing independent injuries that appellants allege here. If the district court were to enjoin the county from offering the BITS program to students in the future, Deal would no longer feel compelled to send Jessica to a neighboring school district to avoid what Deal views as state-sponsored religious instruction. Moreover, an injunction would also alleviate appellants' ongoing feelings of marginalization. We have explained that feelings of marginalization and exclusion are cognizable forms of injury, particularly in Establishment Clause context, because one of the core objectives of modern Establishment Clause jurisprudence has been to prevent the state from sending a message to non-adherents of a particular religion that they are outsiders, not full members of the political community. Which is a common thing that atheists have to face these days, by the way. You can go look up various articles. There's numbers that range anywhere from a few percentage points to more than 30% of American citizens may actually be atheist or agnostic. A rather large proportion of people who have feelings of agnosticism or even feelings of atheism, they don't really want to share them with their community, or they don't want to stand up for those beliefs because, one, they're personal beliefs. As like I said before, many people, including myself, feel that religious beliefs are very personal. I'm quite uncomfortable talking about my religious beliefs with you right now. But that's also because, two, many atheists and agnostics have said stuff before. My mother, for example, who loves me dearly, has said, "It's okay if you don't believe in God, just whatever you do, don't be an atheist." Those are the same things, Mom. That's the same thing, Mom. What she really means is don't tell anybody, because heaven forbid that everybody figured out that you're an atheist. They're going to treat you... Yes, that's what we're talking about. And that's why we shouldn't have had 80 years of state-sponsored Bible instruction in West Virginia, because as you see, now it is so expected to be part of the Bible community that when you're not, you're cast out. As a first grader! Are we kidding? It's not even a thing where like an adult was like cast out because they... I mean, that's horrible too, but at least you could understand it better. A first grader is an impressionable student, the most impressionable of students. An injunction would eliminate the source of that message and thereby redress appellants' alleged injuries. Resisting this result, the county maintains that appellants' avoidance-based injuries are not redressable because Deal did not avow in the complaint that she would re-enroll her daughter in Mercer County schools if the district court were to issue an injunction. But appellants' feelings of marginalization constitute an independently actionable injury. In any event, our standing jurisprudence does not require such formalism. Rather, the removal of even one obstacle to the exercise of one's rights, even if other barriers remain, is sufficient to show redressability. Applied here, the opportunity to return Jessica to her home district, in addition to alleviating appellants' ongoing feelings of marginalization, is surely a tangible benefit sufficient to confer standing. In addition to concluding that appellants lacked standing to seek injunctive relief, the district court held that appellants' claims were not ripe. The court reasoned that, in view of the BITS program's suspension, the court could not evaluate the content of future BITS classes because they do not exist. In so holding, the district court seems to have concluded that because BITS was unlikely to return in its current form, a challenge to it was moot. Where, as here, the parties do not dispute the relevant jurisdictional facts, we review a district court's dismissal based on ripeness and mootness de novo, which means brand new. Like other justiciability doctrines, ripeness derives from Article 3. The ripeness doctrine addresses the appropriate timing of judicial intervention and prevents judicial consideration of issues until a controversy is presented in clean-cut and concrete form. In reviewing a ripeness claim, we consider 1. The fitness of the issues for judicial decision, and 2. The hardship to the parties of withholding court consideration. The district court erred in treating the temporary suspension of the BITS program as raising ripeness concerns. Appellants challenge only the BITS program as it existed at the time the suit was filed. To be sure, any challenge brought now to a future version of bits would face ripeness concerns. This is so because the Establishment Clause requires us to undertake a fact-intensive inquiry that may prove impossible until the precise contours of a redesigned Bible instruction course are known. Under the Establishment Clause, detail is key. Establishment Clause analysis is fact-intensive. Establishment Clause cases are fact-specific, and our decision is confined to the unique facts at hand. But that is not this case. The county cannot, as it evidently seeks to do here, reframe this case as an unripe challenge to some future iteration of bits in order to avoid the demanding requirements of demonstrating mootness. In reaching its contrary conclusion on ripeness, the district court implicitly determined that appellant's challenge to the suspended bits program was also moot. Unlike standing, which is determined at the commencement of a lawsuit, subsequent events can moot an otherwise validly raised claim. A case becomes moot when the issues presented are no longer live, or the parties lack a legally cognizable interest in the outcome. When a defendant voluntarily ceases a challenged program, however, the analysis requires additional rigor. In such a case, it is well settled that a defendant's voluntary cessation of a challenged practice does not deprive a federal court of its power to determine the legality of the practice. Rather, a party asserting mootness bears a heavy burden of persuading the court that subsequent events make it absolutely clear that the allegedly wrongful behavior could not reasonably be expected to recur. In its written submission to the court, the county did not even attempt to meet this standard, persisting instead in its dogged attempt to reframe the issue as one of ripeness. When pressed at oral argument, the county reversed course and suggested that appellant's claims are both moot as to the suspended program and not ripe as to any future reimplementation of the new program. Even assume this argument is not forfeited, it is meritless. The county has consistently described the BITS program as suspended rather than eliminated. Indeed, the county has characterized the suspension as part of a regular review process, a dubious suggestion in view of the program's uninterrupted, decades-long history. Moreover, we have held a defendant does not meet its burden of demonstrating mootness when it retains authority to reassess the challenged policy at any time. Here, news reports submitted to the district court by the county itself emphasize that the county was still vigorously contesting this suit and fighting to retain the BITS program. Rather than enhance the county's case, these press reports reveal the precise problem with relying on a party's voluntary cessation of unconstitutional activity to establish mootness. Indeed, we have routinely found such evidence insufficient. Nor do we find compelling the fact that BITS teachers received a notice from the Mercer County Board of Education that their employment might be terminated. To the extent this has persuasive value, it is undercut by the superintendent's description of the notices as only a precautionary measure driven solely by this litigation, and the school district's mandatory timelines for informing teachers of their ongoing employment status. Such equivocal evidence cannot save the county's mootness claim. In sum, the county has not carried its burden of showing that subsequent events make it absolutely clear that the suspended version of the BITS program will not return in identical or materially indistinguishable form. Appellant's current claims are therefore not moot. Of course, this does not prevent the district court from addressing mootness in the future if presented with that issue. Appellants have adequately pled ongoing injuries that, if proven, are redressable by an injunction. Moreover, subsequent events have not rendered appellant's present claims moot and not ripe. Accordingly, the judgment of the district court is reversed and remanded. Sorry if I seem a little bit ticked off at that lower court judge, because that seems pretty clear to me, and I really don't understand how us attorneys, officers of the court, are expected to be able to figure all that out, but a judge is not. Like, a judge doesn't do their basic Establishment Clause research. So I'm not very happy with the lower district court's ruling, mostly because when you consider the amount of money and time and effort that the appellants had to go through to get into the appeals court, the stress they had to go through, the stress their lawyer had to go through, and all that, I really hope that the county ends up having to pay for all of the fees involved with this case. The last time I saw an appeal with a school district go up and get this far, It was a upper 5-digit case. It was a $50,000 to $100,000 attorney fees case, and it could very easily go higher than that. So this is a West Virginia county that I'm assuming is not the wealthiest county in the United States, and they are probably closer to the poorest county in the United States, and they are going to have to pay for all of this unless somehow they make a deal with the plaintiff. That's pretty stupid. I think that's really, really stupid for a county to hold a Christian Bible school class during the school day for 80 years and not realize that they were not allowed to teach only one religion. That just blows my mind. And then they take a young lady who's in her most impressionable years, and they put her in a closet to punish her for not participating in the Bible study in the public school. That just blows my mind. Blows my mind.
I'm just at the moment thinking I might be doing a lot more work in my job than I might have to. I mean, I remember having to teach a class where we're gonna dissect a heart, and just in case someone becomes unwell, I arranged a different classroom, different things for them to do without knowing that beforehand. Well, apparently I can just put them in a closet.
Yeah. Yeah, if you don't like a kid, just put them in the closet and tell them, you have to agree with me or else you get put in the closet. That's amazing to me. So how could this have been done properly? Let's say that you're a public school and you really, really, really want to teach religion. Guess what? You can. You're allowed to teach religion. This is not illegal to teach about religions. It's illegal to endorse one. You must teach all of them. So you teach a survey course of, religions of the world. And I'm not even exaggerating. Yours truly went to a Catholic university. We literally had to take religion courses, and my religion courses were religions of the world, marriage and the family, and something about child psychology or something, I forget.
So, I mean, even then, for me in the Netherlands, one of the last primary school I went to, your parents could either sign you up indeed to go to the Bible class. This was a public one. So you either could go to the Bible classes 1 hour a week and we learned and we were reading about the Bible. And if you didn't want your kid to do that, there was another alternative class there, which was the more popular option. I don't know what it was because I went to the Bible one. But I think they done artsy stuff. But there was at least 2 options there to pick from. Either you could indeed sit for an hour a week, read from the Bible, or you could do something else, and those provisions were there.
So thanks for listening to me rant about religion. I'm, again, not trying to rant against anyone's Christian or Muslim or other religious beliefs. I have names for my religious beliefs too. Pantheism. I personally think that if there is a God, because I'm not truly a militant atheist anymore, I believe that there could be something greater than me, mostly because I have matured and I don't feel, or I feel that it's arrogant, and I try not to be arrogant enough to say that I know. I'm a limited being, and if you are also human beings, then I'm 100% sure that you're also of limited capacity. We have a lot of capacity, but we also have limitations on our capacity and our understanding. And I couldn't tell you how to make cold fusion work. I couldn't tell you how to reach light speed. How the hell can I say that I know God exists? At least I can test cold fusion. At least I can test the speed of light, or I can test the theory of gravity, or I can go make the laser interferometer gravity observatory. I can't, at least we haven't figured out how, test whether God exists. So how arrogant is it for someone to say that not only do they know that God exists for themselves, but that they also must exist and be forced upon others? And as a former Christian who spent 23 years in the First UCC Protestant Church, and as a militant atheist for a couple years, when I finally realized that that wasn't really the way to go, and as more of an atheist agnostic now, I call myself a pantheist, really. I think that if there's a God in in a similar concept as what I've been taught in Christian religion, it's not a sentient God in the sky. It's certainly not a white man, and Jesus certainly isn't a white guy with a white guy's beard. He would have been Jewish. He would have come from the Middle East, and he would have looked like a Jewish man from the Middle East. He would not have looked like, Ewan McGregor. You know what I mean?
Yeah.
So what I'm trying to get at is that my image of God would be similar to the neurology of the human brain, and galaxies would be, like neurons, and spaceships and people going between, and light going between things would be like communications within the brain, and planets and all that would be, like sources of information, and basically the universe discovering itself is the universe becoming sentient on the longest time scale, billions, trillions of years, and it doesn't even have to happen. This is all by, as far as I know, by physical chance. And to me, that is, just to me, more beautiful than any concept of a sentient man in the sky possibly dictating what happens on one planet in the universe. I don't know. I start to get a little less kind towards my religious upbringing the further I go. So I'm going to stop here. So thank you for joining me, everyone. I am Leonard French, your favorite copyright attorney, and this is Lucy, and that's Penny, and that's the one that peed on my luggage. And I want to thank all of you who support our efforts to make these videos. We currently are still using patreon.com. I understand they're not everybody's favorite platform right now, but we will switch when we have a firm grasp on other platforms, or instead of switch, we'll probably just end up diversifying. But for now, we do ask you to support our channel on patreon.com/ljfrench. Currently, for the month of December, we have Justin Rogers supporting us at the $500 level. I'm working on a video, or will be working on a video shortly here for Justin. Thank you very much for that. Thank you very much to our $50 plus supporters: Jonathon Doe, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Andy, Verement, Tayne, William Gonzalez, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Jax Merrick, and Daniel Perez. And thank you to the approximately 390 or so that are supporting us on Patreon that are not listed here, but will be listed in the description of the video. And when I get back home, of course, we'll figure out the Patreon panel again. So anyway, I am Leonard French, your favorite copyright attorney. I am going to go to, well, actually, I don't know what we're going to go to. I'm going to go enjoy my New Year's celebration in whatever form it takes, and I will see you guys probably on the flip side, probably in 2019. Oh, God. The cats just attack each other.
That cat looks very, very distressed to be sitting next to you.
It's fine.
Yeah, well, I flew drones around, and I wasn't exactly happy that my things got peed on, so I don't exactly like one of the cats either right now. So have a great New Year's. Love you all. Stay safe, of course, and I'll see you in 2019. Love you all.